All right, everybody, thanks for being here today. Thanks for watching online. Welcome to our Estate Planning 101 course. This is a little introductory to estate planning. My name's Terry Cook. I am the managing attorney of the Terry D. Cook Law Firm. I'm a licensed attorney in the state of Oklahoma, but I've got clients that we work with in Kansas, Oklahoma, Texas, Arkansas, Missouri, Arizona, everywhere you can possibly think of, because the license that you carry only allows you to practice in the court system. So when we're doing planning for you, we don't necessarily have to be licensed in your state to help you with your plan. So if you're here from out of state or if you're watching online, don't let the credentials bother you. We can still guide you in the process and help you through that. Because today we're going to learn about basically the basics of estate planning. And, you know, we've all heard those horror stories of how, you know, oh, when Grandma and Grandpa died, it was just a mess and everything was, it took so long. It was in probate for years, and by the time it was all done, everything ended up getting sold and the attorney's the only one that got anything. You know, everybody's heard one of those or unfortunately had to have been part of one of those stories. So today we're going to try to answer all your questions so that you don't end up in that situation for you or your family. So we start out with, what exactly is it that needs protecting? Well, first of all, you need protection. Your family, you know, especially if you have minor children. If you have minor children, pay close attention today. Your financial assets, your real property assets, and your personal property assets. So we'll start off first with, well, what do I do? How do I protect me? Well, first off, we'll start with what's known as a living will. And a living will should not be confused with a last will and testament. A living will has to do with taking care of your wishes in case you are incapacitated while you're still here and alive. A living will allows you to direct through the language of the document itself or by appointment of a representative of your choosing what your wishes would be in certain healthcare type situations and things of that nature. So what exactly is a living will? Like I said, this is a group of documents actually that is used for while you are still living, and it's generally comprised of two powers of attorney: a healthcare power of attorney, a financial power of attorney, and an advance directive for healthcare. A special note to remember here in this situation is all of the estate plans that we do at our law firm, they will include those living will documents as part of the planning. So there's no need to have to purchase those documents separately unless you're in a situation where after we're done, you think, you know, I think I'm okay. I don't think I need a formalized estate plan, but I do need to take care of those living will documents. So all of those are included in any plans that we would do, but everyone should have living will documents in place. So if you don't have those in place and you don't do any formalized planning, you might strongly consider at least just doing those after the seminar is over. So we've talked about how to protect me. Well, what about my assets? That's financial assets, that's real property, that's personal property. These are the things that make up what's known as your estate. And these items, along with your specific family needs and your circumstances, are really what determines if you need a formalized estate plan. So we start out then, okay, these are my assets, so what exactly is my estate? Well, your estate is all of those things, and the value of the estate is basically your net worth, and that's at any given time. That's while you're alive and when the time comes to handle your estate after you're gone. So we add up all of the values and all of the property that we own. That's real property like land, mineral interests, things of that nature. Financial assets like bank accounts, 401ks, IRAs. It's contractual interest, such as ownership in an LLC or a corporation, things of that nature, and it's your personal property. You add all of that up, then you subtract away any liabilities or money that you owe on any of the assets, and that gives you basically your net worth. So we start out with, all right, I've got my estate. Who has the rights to my estate? Well, it's an easy question while you're still alive. While you're here, you have those rights. The bigger question comes after you pass on. So after I die, who has the rights to my estate? Well, there's a reason there's a big long blank there with a question mark, because I don't know. There's not one answer for that question, because different assets are treated differently. So we have to know, okay, how are the rights to that type of asset determined to figure out who would have the rights to it. And the problem with it is that different laws determine who obtains the rights depending on what type of asset it is. Each type of asset that we talked about a moment ago is governed by a different set of laws. There's a different set of laws that govern financial assets. There's a different set of laws that govern your personal property. There's a different set that covers real property. So everything's kind of operating under different rules and different systems. So a formalized estate plan is a way to unify the rules dealing with the distribution and the treatment of your assets when the time comes, and a way to unify the rules to a system that you have designed. So, how do I know if I need a formalized plan or not? Is it the value of the estate that determines it? Is it my final wishes that determines it? Do the type of assets I own determine it? What about the cost of administration afterwards? Is that what determines it? Well, the short answer is yes, all of those things determine it. A special note that you will want to make a note here if you're taking notes, or if you just want to make a mental note here, there's not really a single question that anyone can ever ask you to say, do I need a plan? There's just not a one-size-fits-all answer for that, and especially the value, or more precisely, the perceived lack of value in an estate is never a reason to say, I don't need an estate plan, because the value alone of your estate doesn't make that determination. Depending on what type of assets you own, you may need a formal plan in place, or you end up putting your family in a position where it costs them more time, trouble, money to get everything squared away when you're gone, just because you thought, oh, well, I'm really not worth that much. I don't need to have one of those kind of things in place. That's a bad situation to put yourself in. So, even though there isn't a single question that could be asked to say, do I need to have an estate plan in place? There are a few quick questions that you can ask yourself to know, should I strongly consider this? The first one is, do you have minor children? I mentioned earlier. If you have minor children, it's one of those where, okay, you can kind of check out for a second, take a rest, come back to us in a minute, skip to the back of the book. Yes, if you have minor children, you absolutely need to have some kind of a plan in place. This next question is, do you own real property? And most of the time, the answer in that situation is yes. There are exceptions with real property to where if you do other forms of planning ahead of time, you don't have to have a formalized estate plan whenever you pass to transfer those assets. But those exceptions themselves even require some pre-planning. So make sure that you consult an attorney or a professional planner before you think that you fall into one of those exceptions. Don't just listen to Joe Blow at the coffee shop and say, oh no, all you need to do is this. Well, unless Joe Blow's an attorney that practices in estate planning, I would probably continue to get a little bit more information. Another is, do I have particular wishes for my distribution of my estate? If you have specific plans as to who you want certain assets to go to, you need to have a plan in place. Or do I have loved ones with special needs? Do I have family that are on disability? Or do I have children or family members that are receiving assistance from some state or federally funded program where if I were to leave them an inheritance, it might affect their ability to continue receiving that benefit? You got to be careful about those. So a note to self right here is, if you answered yes to any of those questions, at the very minimum, you should probably schedule a free consultation just to have us, look over your personal situation with you, give you a little guidance as to exactly what you should or may not have to do moving forward. Because everyone hears, well, aren't there other ways that I can transfer those assets? Well, yes, there are other ways, but it all depends on the type of asset that you're wanting to transfer and the specific circumstances surrounding it. So my advice is, like I said, always consult an attorney before planning an asset transfer method like that. Even if your plan is to not create a formalized plan, if your plan is to do something else to make sure that asset avoids probate or things of that nature, and actually I should say especially if your plan is to try one of those other methods, always consult an attorney before doing so. And in case you didn't hear me the first two times, always consult an attorney before you make those types of changes, because there are taxation and other legal aspects that can come into play. So you have to be extremely cautious if you're attempting to circumvent probate or trying to get property passed without having to go through those administrative processes, because if you choose incorrectly, your estate will not be able to fix the problem because you are the one that transferred the property. So if you're not there any longer, you can't go back and undo the mistake. So if you incorrectly set up the plan for distribution, there can be significant tax consequences that will simply at that point be unavoidable. So what exactly is an estate plan? Well, an estate plan is the administrative process that's used. It's a plan that's used to distribute the rights to the property and the assets of your estate. That's all it is. It's basically just a predetermined administrative process. So how does it work? Well, it can work in one of two ways. You can use the public administration system, which is the probate system, which is administered and overseen by a judge of the court, or you can use a privately administered system, which is administered by someone of your choosing, like a trustee or a corporate officer, things of that nature. So there's basically two paths to go down in that aspect. So what are the types of estate plans that we can look at? Well, everybody, I'm sure, has heard of a last will and testament. You've probably even heard of revocable trusts, maybe even heard the term of an irrevocable trust, such as dynasty trust or special needs trusts. And there are also corporately structured plans, where you use family LLCs, corporations, things of that nature. So we've got all these different types of plans, and today everyone is here because you've done like a little assessment of your situation, and you thought, I need to get some of this information, because where do I stand right now? What if something happens to me? What would happen to my assets? And the reason most of you are here now or watching online is because, well, I don't have anything. I don't have a plan. So what do I do if I don't have a plan? Well, that's a little bit of a trick question, because everyone has a plan. It's just whether or not you have a plan that you created for yourself, or if you have a plan that the state has created for you. And the state-created plans are what is known as the laws of intestate succession. And most of the time, those laws are not what you expect them to be. You would think with common sense a lot of times that you know what's going to happen with assets, but in reality, the laws don't follow what you think. So let's have a look at it real quick. Let's say I pass away and I have children, but no spouse. My spouse is already gone, I'm the last one, and I have children. Well, in that case, the children inherit equal shares of the estate. So that's probably what you wanted. So in that instance, the state laws may be exactly what you want to happen. Well, let's take it another step. Let's say my spouse is still alive and I've got children. Well, most of us, if you were asked, would say, well, I would assume that everything goes to my spouse. And most of us would be wrong because that's not what the laws of the state allow for. The laws actually say that your spouse inherits half and your children and spouse share in the other half. So sometimes that can cause issues later in life for your remaining spouse because all of a sudden little Johnny is sticking his nose in business where it doesn't belong and causing issues. And for another example, say that you don't have children, but you pass away, your spouse is still surviving, but you also have siblings. Again, you'd probably say, well, everything's going to go to my spouse, but that's not true either. Your spouse will actually inherit all of the property that you jointly acquired during your marriage, but if there's property that you owned prior to the marriage, then your spouse only receives 1/3 of that, and the other 2/3 is split equally among your siblings. So, as a special note here, you just want to know that the rules aren't going to do what you want it to do, and the use of intestate succession through the probate process is the most expensive method to pass property. It doesn't cost you anything today, but it costs your family the most amount of money in the process in the long run. And this is one of those things that lawyers just don't want you to know. And I say that, I talk about lawyers like I'm not one of them, and I am, but different attorneys do business in different ways. And a lot of lawyers don't want you to know about the back-end cost of planning because by the time it rolls around, you're dead and gone, and you can't complain about it, so your family's on the hook for them to roll up the register and just sit there, ring the register for the whole time that it's going on. So you have to be very careful about the type of planning that you choose and make sure you understand both the front and the back end. A quick, easy note for yourself here is to know that assets with a paper title, meaning land, meaning cars, trucks, things of that nature, contractual interests like ownerships in an LLC or in a partnership, or and even financial accounts, you have to assign a beneficiary to those. If you don't take some formalized steps, you're going to be in trouble because they do require formalized structural transfer of those interests. And without one, a probate will be required and your wishes will be irrelevant. It will not matter. You can have 100 witnesses all go up to the stand and say, Your Honor, I swear this is what they wanted to happen. And at the end of the day, the judge is going to say, that's all fine and good, but the laws of the state say I've got to do this. So, my legal advice to all of you is every one of us should at least have a last will and testament. Well, I thought you said earlier, well, if you needed to have a plan. I did say if, but yes, I did say everyone, and I do mean yes, everyone. And the reason for that is because of the expense and the problems that come with an intestate probate can be avoided by having a last will and testament. So even if you're in a situation where you don't think I own any assets or have any property that needs to be planned for, you never know what's going to happen. You just never know when some other family member, some distant relative, maybe didn't plan, and now through the laws of intestate succession, you inherited an interest in some property from them that you didn't even know about. Or, you know, say you hit the lottery. If you do, give me a call. I would love to retire with you. But things of that nature, you just never know when these types of assets might fall in your lap. And so, in my opinion, it is better, it's way less expensive to go ahead and spend that little bit now to have that security there whenever the time comes than to roll the dice and not have anything in place and need it. So, you're probably thinking to yourself now, okay then, so I know we've got all these different types of plans. I don't know, what type of plan should I use? Well, the first thing to ask yourself is, what's the difference between the plans? Well, the good news is that all types of formalized plans are ways to administer the assets of your estate according to your wishes, and they all will accomplish the same ultimate goal. Now, I say ultimate goal because at the end of the entire administrative process, when it's all said and done, all of the different methods will been able to have passed your property to whoever you designate that the property should go to. But sometimes in that process, you have specific needs or specific wishes that you want to accomplish. Say you want to be able to set aside a portion of your estate to hold on to pay for your grandkids' college or something like that. And so you want it to be held over a period of time. Well, you don't want a probate to be extended over that period of time. So some plans can do things that other plans can't do. So again, we say, what is the difference? Well, the main difference in the types of planning mechanisms is in the administration process itself. So let's just compare what we've got. If you have a last will and testament, it uses the public administration process. It's administered through the probate process in the court system, and it's overseen by a judge. With a trust or with a corporate plan, it uses a privately administered system. It's administered by the person that you appoint to be the trustee or the corporate officer of that instrument, whether it's a trust or a corporate plan. A last will and testament in the public system, the last will and testament directs the judge of the court how to act, how to distribute your plan. Same thing with a trust plan or a corporate plan. It privately directs your trustee or your officers how to distribute those things. With a last will and testament, using the public administration system, they can be contested, and they can be easily contested. That's the part that I really kind of shake about a little bit. And why? The reason I say that is because when you use the public administration system, you have to take that last will and testament and enter it into the court system and open a forum to rule on that will. So once you file that petition to probate that will, the forum is already open. So anyone that wants to come in and stake a claim against the estate has the ability to just show up and do it. And the judge is going to be required to listen to what they say. Even if it's, good, bad, indifferent, the judge is going to have to listen to what they have to say. And the cost of the contestation affects the value of your estate. Even if their claim is completely bogus, your family is paying your attorney to handle that probate process, and they're going to have to sit through it and listen to this person's complaint. And they're billing you by the hour, so it's just costing your estate. So it can be contested, and you pay for it. With a privately administered system, it still can be contested, But it's much more difficult to do so because now there's not an open forum for it. If someone wants to file a claim against the trust or against your corporate plan, they have to file that petition to ask the court to open that forum. And in drafting your trust plan or your corporate plan, there's ways that we can draft language into those documents that in case someone does that and tries to open a forum to complain, there can be language written into the trust that says, depends on what you're asking for. If you're coming in here trying to sue so that you can get property from this trust that you think you're entitled to, then you're automatically removed as a beneficiary of the trust. And what that does is it removes, in a legal world, what's known as your standing. And now you don't have a dog in the fight. So the judge is going to just say, case dismissed. So the forum itself, for anybody to complain, never even gets opened. So they're much more difficult to contest. Also, using the public administration system with a last will and testament, you should have a plan where all of your assets can be distributed at one moment in time. You know, at the end of the probate, the judge can just say, all right, let's divvy everything out, here's where it goes. With a privately administered plan, you can have a plan that does that, where everything gets administered all at once and distributed, or you can have a plan where it stretches out over time, like, for instance, you know, saving for grandkids' college or something like that. But the administrative cost of it in the private sector is much, much, much lower and maybe even non-existent. But in the probate process, if you have a plan that is going to continue over time, that probate has to stay open until all assets can be distributed. So all you're doing then is just allowing that attorney to ring the register on the probate. Also, with the public system, there are significant costs both on the front end and on the back end. Now, the costs on the front end are significantly lower than what you see with trust planning or corporate planning, but the cost on the back end is enormous. So you have to be aware of what those costs are going to amount to in total, not just what is coming on the front end. The difference with the corporate plan or with the trust plan is that virtually all of the costs are on the front end, so you know what you're paying. There's no unknown cost coming later to hit you. You know what the total cost of the plan is going to be, so there's no time value of money considerations to worry about. You don't have to worry about, okay, well, I know what the cost would be today, but I'm actually not going to pay for this for 10 years or 20 years, so how much inflation is going to affect that? You know, with a trust plan or a corporate plan, you have all of those costs up front. You know what they are. So you kind of see the difference between the two administration systems. So let's start by asking, okay, is a last will and testament even an option for me to use for my planning? Well, first, does your family have the cash to pay for the probate? This is a very important question because at the end of the day, the lawyer, the court system, all of those expenses in the probate are going to get paid. And if your estate doesn't have cash assets available to pay those, what's going to happen is the judge is going to order that property go to sale. And we liquidate that property in order to pay those bills. And that's those horror stories that you've heard when people say, well, you know, grandma's estate ended up going to auction and we didn't get anything out of it. You know, that's how those stories come about, is that the probate process had to be used to transfer title to the property, but it turned out there wasn't any cash to pay for the process. So the property that the family was trying to probate had to be sold to pay the expense. So you don't want to put yourself in that kind of situation. So make sure if you're planning on using a last will and testament plan that you have cash available set aside for that cost later. And you have to know ahead of time and be okay with the fact that the cost of the probate and the cost of the will together is going to be significantly more expensive to your estate than some of the other methods would be in the big picture. But the good part about it is that you get to defer a big portion of that cost until later. So you can use other methods and mechanisms to help pay that cost, such as life insurance, things of that nature, to make sure that there's cash available when the time comes. And then finally, does your distribution plan allow for your assets to be transferred all at one time? Because if you've got special needs, children or relatives that are on, disability or some other kind of state-funded program, and you're going to need to hold on to assets and give them out a little bit at a time, you don't want to do that in a probate because it just extends the cost of the administration process. So, if all of those things are clear and okay with you, then a will is an option. So let's have a look at, okay, what are the ups and downs to it? Well, as we've said, they're less expensive on the front end. They're far less expensive. They're a very minor expense on the very front end. And they have the best oversight because there's a judge involved in the court that's overseeing everything that happens. So there's the lowest possibility of abuse in the administrative process. And using a formalized estate planning device, such as a last will and testament, or a trust, things of that nature, allows for all of the tax benefits that come with transferring assets upon your death, rather than creating some of the tax burdens that you can create by trying to pass property to your children or other family members while you're still alive, while everybody's involved in the process. So on a tax basis, it leaves all the doors open to make sure that everything gets done properly. The downside is that they are the most expensive to administer on the back end. And the thing to know here too is that probate attorneys aren't motivated, to finish quickly and efficiently like you are. They're getting paid by the hour, so where's the motivation for them to get finished? I'm not saying that any of them are dishonest or anything, but I'm just saying, they're not going to be, all gung-ho about, hey, let's get this done on the deadlines exactly for every filing so that we're done in the shortest amount of time. It just doesn't happen. Also, all assets need to be transferred, as all assets have to be transferred before you can close that administrative process. So anything goes wrong, somebody contests it, somebody makes a claim against the property, just another relative comes in and tries to say, oh, I'm a child as well. Anything that happens drags that out, and until you get all of that settled and resolved, you can't close the process and stop the register from ringing as far as what the estate is paying. Probate process, like I said, it can take years to finish. I've got a good friend that his family is still in a probate process that's been going on 10 years. So you never know how long it's going to take. You know how long you hope it's going to take, but no attorney can ever tell you exactly how long it's going to take because you don't know what might happen once you get started. But the average probate's going to take you at least 6 months. So it's not a quick and easy process no matter what, no matter how the system goes. They can be freely contested, as we mentioned, and that cost is going to fall to your estate. And they're also expensive to amend or change. And just a quick tidbit, I as an attorney, I would never recommend that you change or amend a will by manner of what's known as a codicil, by making an amendment. If you're going to change your will, once you've got it drafted, you're better off to just draft a brand new one and then burn the old one. Because when you have a will, a will has to fit into a certain set of guidelines and rules under the statutes of the state that you live in. And if any of those rules aren't followed correctly, then someone can fight that will and get it tossed out of court. If you do a codicil to the will, now I've got 2 documents that I can pick on. So I'm not a big fan of doing amendments or codicils to a will. If you have a will plan, or if you make a will plan and then later you decide to amend it, you're better off just replacing it completely. But when you do that, there's going to be a cost to it. So they're fairly expensive over time. So as a younger person, you might be better off to consider some of the other planning mechanisms that might be a little more cost effective. So real quick, let's talk about another one of those things, a couple of those things that lawyers don't want you to know. The average cost of a probate here in Oklahoma in 2015 was approximately $3,800. Now, that number might vary depending on where you get your information, but you're going to find that it's roughly in that same neighborhood. And like I said, the expenses of the probate are going to get paid before your family gets anything. The attorney's going to get paid, and the court fees are all going to get paid, and any creditors that come along are all going to get paid before your family gets anything. And if the estate doesn't have the cash to pay for it, like we talked about, all of the assets of the estate are going to end up for sale to pay those bills. So again, my legal advice to you in this situation is if you have assets that require some form of formalized estate plan, or if your choice of distribution leads you to believe that I need to have a plan in place, I advise using a trust plan because it is usually more financially efficient than a will and the probate process. So if you are financially capable of paying the expense up front to set up a trust plan or some form of privatized planning mechanism, that's really what I recommend. Now, I want to be careful here and make sure that you don't hear me incorrectly, because I am not saying that wills are a bad way to plan. A last will and testament is still a much, much, much better way to plan than having nothing in place at all. I'm just saying that if you are in a position to where you can really be comfortable financially choosing any of the methods, a trust plan is probably a better way to go in the long run as far as the efficiency and the cost to your estate. So we've talked about wills. Now let's talk about the privately administered plans. These are the traditional revocable trusts. This also includes certain types of irrevocable trusts, asset preservation trusts, dynasty trusts, special needs trusts. You may have heard the term Medicaid trusts, things of that nature, or even the use of corporate plans. These are the privately administered plans. So let's have a look at those. Well, the good thing about those is that virtually all of the expense is on the front end. So I know what it's going to cost. I can tell you right now, this is what it's going to cost to do your plan. There's no unknown cost coming later that I have to guess at. Also, the privately administered plans are administered by the trustee that you appoint, and the rules for the trust are set up in the trust document itself. So you can set that oversight level as strict or as lenient as you want it. You can make it as strict as the court process or even stricter, or you can make it as easy and lenient as possible so that it fits your needs. There is no court intervention. There's no public record of it. It's all privately handled, so no one is all up in your business. And you maintain full control and rights over all of the property that goes into the trust as long as you're alive. You are still the one in control of everything. They're very easily amended. And sometimes they're so easily amended that you don't even have to have an attorney involved to do it. It all just depends on how the language of the document is written in the first place. But they are much easier to amend because they don't have to fit into those statutory rules like a will does. And they also allow for all of the tax benefits of using a formalized estate plan and passing assets at the time of your death, rather than trying to pass them during your lifetime. Now, the downside is that you have to be very careful when setting that oversight level, Because if you set that oversight level too low, there is the potential for misuse and abuse of the process. I'm not saying that it would happen, and I'm not saying that it's right. I mean, if a trustee abuses the system and takes advantage of your trust and takes things from it that they're not entitled to, it's still stealing. I'm just saying that if you set that oversight too low, you can put them in a position to where when they're administering the system, the temptation might be there. So you want to make sure that you set the right level of oversight, because that can be a downside to doing a private plan. And a downside is they're more expensive on the front end. Well, I thought you said that was a good thing. Well, it's a good and bad thing. It's good because we know exactly what the cost is. There's no unknown cost later, which we'll talk about in a little while when we get to the real numbers of what these types of plans cost. But the downside is that they are quite a bit more expensive on the front end when you compare it to a last will and testament plan. Now, as far as the irrevocable trusts or corporate structure planning goes, I would just advise you to call our office, consult, an attorney of your choice, set up a free consultation with us. We'll come sit down, look at your plan, look at your circumstances, let you know, which way might be best for you. But those complicated plans are a little bit outside of the realm of what we're trying to do here with just an introductory type seminar. So if you think that you're in a position where you need an irrevocable trust or a Medicaid plan or some kind of family corporate plan, just talk with us after the seminar, or if you're watching online, just at the end, just contact us at our office and we'll set up an appointment to talk to you about it. But right now, the question that we all want answered is what? It's what does it cost? What is this all going to cost me? Well, real quick, we'll jump back to the living will documents that we talked about. I can only speak, of course, for my firm, not everyone else. But when you do living will documents with our firm, it's comprised of 3 separate documents: healthcare power of attorney, financial power of attorney, and an advance directive. I always recommend that you do a healthcare and a financial power of attorney separately. The reason being, for healthcare purposes, you always want a power of attorney that is appointed. In case of emergency, there's someone there that can step in and take charge for you. But you don't necessarily want someone who's already appointed to be your financial power of attorney. So we always separate those because we generally make the healthcare power of attorney effective now, make the financial power of attorney what's known as a springing power of attorney, which basically means it's not functional until or unless the time comes that you ever become incapacitated and need it. Then it's there to be able to do its job. And then an advance directive for health care. We do those living will document packages for $300. I'm sorry for those of you that are single here or single watching online. Couples get a better deal. We do them single or couples. It's just a $300 package for the living will documents. So the next one is, well, what if I do nothing? What if I'm not going to do a plan and I'm going to follow the laws of intestate succession? What's it going to cost me? Because there is a cost. Don't kid yourself. Now, up front, that cost is zero, and that's the good news. But that's all the good news. The average cost of an intestate probate is about twice as much as a probate with a will. And the reason for that is because probate process is about this long, over a timeline. Well, if you don't have a will, you have to follow all of those processes. If you have a will, then the will tells the court some things like who your heirs are and other issues that can skip you forward in the process. You can kind of, well, I don't have to have all these separate little hearings for this now. I only have to do this much of it. So not having a will, the average cost of an intestate probate last year in Oklahoma was about $7,500. The big thing here too, is this cost fixed or can it change? No, it's not fixed. It can change. It will change, and most likely it will increase. Nothing seems to get cheaper in this world. So your total estimated cost is about $7,500, and that's what I mentioned earlier. That's what I don't like about it as a planner. When I'm sitting here telling you how to set up your estate, I don't like unknowns. That's not what I'm here for. That's not what any attorney or any planner is there for. We're here to help give you answers, and that's one I can't give you. One answer I can give you, $7,500 for an intestate probate last year in Oklahoma. I guarantee you this, you ain't gonna die last year. You know, that's just all there is to it. That number really is nothing. It's just a reference, because it's no good today. And even if it is, on average, that still doesn't mean your case might not be average. It might be less, it might be more, I don't know. And that's the thing that we don't like. But either way, you're betting the odds that the cost is going to be somewhere in the neighborhood of $7,500 or more. So that's not a good place to be. Okay, so what if I do a will? What if I do just a last will and testament? What are my normal costs? Well, and I say normal costs here because this is what our firm normally charges to do these types of plans. If you're here today participating in a group plan through your church or through your organization, and there's special pricing available for you, just see us after the seminar, or if you're watching online, just contact our office and we can give you the rundown as far as what the participation level is and what the exact costs of your plans would be. But on normal plans, we do a will plan for $600. That includes your last will and testament and all of those living will documents as well. And as we said earlier, the average cost of a probate in Oklahoma last year was $3,800. And that's that part that those attorneys don't want to talk to you about. They don't want you to know that bill's coming. And again, it's not fixed. This cost, it's going to change. It can increase. Most likely it will increase. So today I can tell you that the estimated cost of doing a will plan is about $4,400. You know, so don't get fooled if you go talk to some attorney and they say, "Oh, I'll draft you a will for $300." You know, that's not the whole story. The average cost is going to be somewhere in that $4,400 range. This is a big room, and so the print on this slide is fairly small, but I'll tell you what it says here at the bottom is that this is an estimated cost of what a probate will be in 15 years. The estimated cost of a probate in 15 years, calculated at an average annual rate of inflation of 3.22%, which is basically what the average inflation rate has been in the U.S. over the last 20 years. The estimated cost of a probate 15 years from now will be about $6,400. $6,434.54 to be exact. So you're looking at closer to $7,000 in total expense if you live for another 15 years or say 20 years. That cost of doing a will plan is going to increase over time because the cost of the probate is going to increase. And I don't know what that number is going to be. So I can't tell you what the cost is. I can only tell you it's probably going to be at least $4,400 and maybe more. So what about a trust? Well, the normal cost for a regular revocable estate planning trust, which is the most common form of trust plan used. Our firm does those typically at a flat rate. It's a $2,800 expense. Now, that can vary a little bit depending on if you have property in multiple states or things of that nature, if you're in a different type of situation. But that's why we do the personal consultations, is so we can figure out exactly what is your personal situation and make sure that we give you a good hard price before you go into it so you know exactly what it's going to cost. And the administration expense on the back end is virtually zero. Now, don't hold me to the fire here, because the expense is not zero. If your estate holds property or things of that nature, there's going to be some fees involved with filing deeds to transfer things out of the estate, but those administrative expenses are virtually non-existent, especially compared to the cost of a probate and using the publicly administered system. And here's the kicker. Is this cost fixed? Yes, it is. That cost is fixed. That's what it's going to cost you now. Now, know this too, as far as with our firm, $2,800 is a lot of money to have to, pull up out of your pocket. I'm sure most of us aren't carrying that around today. There are payment plans that you can set up. We're very easy to work with as far as making it comfortable for you to be able to pay for the plan without having to, come completely out of pocket with the money right up front. But that is the cost. That's going to be the total cost to you. There's no hidden fee coming later. So your total cost is $2,800. So we start out, what if I do nothing? I'm up here at $7,500. Well, what if I do a will? All right, I cut that down to $44. What if I do a trust? Now I'm down to $28. So you can see what I mean when I say, the costs vary, and you have to look at the total cost of the plan. You can't just let some planner or some attorney tell you, oh yeah, just do this will plan because it's only $500. Because they're not telling you about that expense on the back end. And they know when the time comes, their name's plastered all over your will, your family's going to call them to do the probate. I've even I've seen attorneys in my career that won't even offer to do trust planning for clients because they know if I do wills, that generates future business for me. So just understand how that works. And another thing about doing trust planning is you've got to understand a trust plan is a two-step process. Because I know there's going to be some of you out there that's going to see this and say, well, and write it down and then immediately go shopping. Go try to find a better price. Well, understand this. Creating a trust is a two-step process. The first step is doing all the legal work to create the entities and get everything set up. The second step is what's known as funding the assets to the trust. And the second step is just as important as the first. If you have the best system in place and you don't get it properly funded, it's not going to do its job for you when the time comes, and you're still going to end up in a probate court. So you want to make sure that you know you're getting what you need when you do a trust plan. How will the funding process be handled? Is the planner going to do it all for you? If they tell you they are, they're lying to you. There are certain parts of the process that I can't do for you. I can try, I can do the best I can, but for instance, I can't get your banker to assign your bank account to your trust. No matter how many times I show them my law license and, stand there looking pretty in my suit and tie, they're not going to do it. It's your account. You're going to have to tell them in those. So you're going to have to be involved in that process at some level. So don't let someone fool you by trying to say, oh, we do everything. You don't even have to do anything. That's not true. You're going to have to help in that process. So is your planner going to help you with the funding? Or is your planner going to make you do the funding yourself? Because I know there's a couple of you probably out here that have said, oh, well, I know old Joe Blow down the road. He'll do us a trust plan for $1,500. And that's probably true. And he's probably only going to do the first step. He's going to do all the legal work for you. And then he's going to give you all of that documentation, maybe with a letter if you're lucky, that guides you and tells you this is what you need to go do to make sure everything gets funded. So I just ask you, if you're paying your attorney or a planner to do your planning and they're only going to do half of it, what are you paying them for, That's really not a good way to roll the dice, because if the funding process is not followed properly, then the trust plan is not going to work properly in the end. Also, are you getting any assurance from your planner, that the titles to your real property that's going into it are clean? Are you getting any protection from your planner that says in the future, if anything comes up, if there's ever any quiet title claims or anything like that that comes up on my property, do I have protection from you that you're going to take care of that? Or is there going to be another bill waiting for that on the back end? And are they going to provide you with the documentation that you need on the back end to administer the plan? Or are they just going to be sitting around waiting for everything to happen, and after you're gone to come back and another bill is waiting for you then whenever all that documentation comes around? So I would just let you know that any of the plans that our firm does, all of the plans that we do, we will fully assist you in the funding process, and we will take care of all of the funding process that we are capable of taking care of without your assistance, such as we'll have you sign and execute deeds for property, deeds for mineral interests, things of that nature, real property. We will have you sign all the documentation you need, but then our office will do all of the filings, all of that, to make sure everything gets filed with the proper county authorities and everything is funded properly. And we will guide you with all of your financial resources to make sure that you contact those people. We'll send them all of your financial institutions will get a letter from our firm saying, that your wish is to assign that to your trust. But most of them are going to require you to fill out an interior, form for their process, one of their forms. They're not going to take it from our letter, or they're going to want to talk to you in person. But basically, we are going to make sure that everything gets done right, not only on the legal side of things, but also on the funding side of things. So for those few of you out there that want to look for a good deal, it's one of those things where be very careful. You might get what you pay for. And now as far as the cost goes for the irrevocable plans, Medicaid plans, corporate structured plans, LLCs, family LLCs, things of that nature, those can vary so much that my advice there is, if you feel like that type of plan is what you're looking for, just contact us. We'll sit down with you for a free consultation and tell you, no obligation to us. We'll tell you what do you need to consider, which ones might work for you, and then once we can narrow it down, then we can give you a good solid price. There's my email address there. It's tcook@terrydcooklawfirm.com, and there's the number 918-243-5034 to the office. So just give us a call, set up an appointment. But otherwise, if you've gathered all this information and now you've decided, okay, I'm ready to go, how do I get started? Schedule your consultation with us now. Call the office, email me, one of those. We can schedule a time where we can come sit down, talk about your specific situation and circumstances, and make sure that you've made the right decision as far as which plan you're using, things of that nature. And if through this you've decided that you're not going to do planning through our law firm, I would just encourage you to please consult a professional, a planner, or an attorney about doing it. And when you do, keep this in mind. Attorneys are just like doctors in the respect that we all seem to specialize in certain areas. My firm does almost exclusively estate planning, contract work, or taxation planning. So we're very well versed in what we do, and you don't want to go to someone who doesn't quite know all the ins and outs of it. I say that, we're kind of like doctors in the fact that, if you break your wrist, you don't want to go to the proctologist to get it fixed. You want to go to someone who really knows what they're doing with the right type of service for what you need. So here's our information again. There's the address to the firm, office number. There's my cell phone number. You can actually call me directly as well. You can call and speak to them at the office, or leave a message at the office, or email. So if you're here today, after we take questions, you can just meet up with one of us. We'll schedule a time for you today. If you're watching online, just contact us either by phone, by email. Either way, we can get back with you, and we can either schedule a personal meeting for your consultation, or we can handle it over the phone, teleconference, FaceTime, whatever works best for you. So in the meantime, right now, we could go ahead and see if anyone has any questions.